Tesla and the stockholders can't give up the benefits of Mr. Musk's incredible labors for the last 7 years, nor can Mr. Musk give back all of the work that he put into the company over those years to achieve that extraordinary success.
All right, guys, so before I show you the entire court case today, I'm going to put it in context. Today's Tesla's attorneys will face an uphill battle. They have to convince the 5 Delaware Supreme Court judges that the 2024 Chancery Court verdict in the Tornetta case needs to be reversed. And the Tornetta case refers to Richard Tornetta, who filed the lawsuit against Elon Musk and Tesla's board of directors. The core allegation was that Musk's 2018 performance-based compensation package, initially valued at approximately $2.6 billion but later ballooned to over $56 billion due to Tesla's stock surge, breached the directors' fiduciary duties to the company and its shareholders. Tornetta argued the package was excessive, unfair, and the result of Musk's undue influence as a controlling shareholder. So to recap before we watch, in 2018, Elon got this compensation package. If he got Tesla to certain milestones, he would get paid a lot of money, $56 billion. Then this guy, Richard Tornetta, who owned a very small amount of Tesla shares, filed a lawsuit. And then the Delaware court rescinded Elon Musk's pay package. They said you should not get paid, citing reasons that the package was either excessive, unfair, or the result of Musk's undue influence. So then in 2024, Tesla had shareholders re-vote again after Delaware's decision, saying, now that you guys know these things, do you still want Elon to get paid? And the shareholders voted in favor. Yes, Elon Musk should get paid. But then the Delaware court didn't let that go through either. So again, today Tesla's attorney needs to convince the 5 Delaware Supreme Court judges that the 2024 Chancery Court verdict, as I just discussed, needs to be reversed.
Thank you, Mr. Chief Justice, and may it please the court. Chris Michel on behalf of the director defendants. In 2018, my clients agreed to pay Elon Musk nothing unless he doubled Tesla's then $50 billion value, the equivalent of creating another Ford or GM. If he did that 12 times over, exceeding the entire combined value of the US auto industry, he could keep up to 10% of that growth. That highly favorable all upside deal was approved twice by Tesla stockholders. And the Court of Chancery's decision rescinding the award in full is wrong for the reasons we elaborated in our brief, 3 of which I plan to emphasize this morning. First, the Court of Chancery applied the wrong legal standard to the award by conflating Musk's influence with control of the transaction and by discounting the stockholders' fully informed vote. Second, the court misapplied entire fairness by asking whether the directors could have gotten a better deal rather than whether the deal that they made was fair to stockholders. And third, the court legally erred in imposing the remedy for any breach by rescinding the award in full, even though that relief would not restore all parties to their positions before the transaction. Beginning with control, the Court of Chancery's central error was to detach the controlling stockholder determination from its foundation in stockholding. The court held that Mr. Musk was a controlling stockholder even though he owns less than a quarter of Tesla's stock, has no right to block transactions, and recused from the vote on the award. Simply put, even if transaction-specific control is a valid method for determining a controlling stockholder, Mr. Musk did not come close to exercising the actual control over the transaction that this court recently clarified was required in Oracle.
So I want to just stop you there. It's pretty clear from the record that you did not argue that transaction-specific control was not a viable theory in the Court of Chancery, correct?
Mr. Chief Justice, we think we did preserve that argument, but my fundamental submission this morning is not.
I want to just press you on that, and I know time is precious. But where did you preserve that, other than some general statement about he was not a controller?
Yeah, in the early proceeding, we did say he was not a controller. The vice chancellor at that stage said he was going to proceed on the theory that transaction-specific control was allowed, and we didn't have another opportunity to object until now. But with your permission, I don't want to focus on that issue this morning. I do want to focus instead on the actual control that is required to be exercised to create transaction-specific control, even assuming that that's a valid theory. And that's what's lacking here. I think the most straightforward way to understand that is that all of the conduct that the Court of Chancery relied on in its controlling stockholder determination could have been conducted by somebody who owns no stock at all. Thus, a non-stockholder could be a controlling stockholder, and that position, I think, underscores the real flaws in that aspect of the court's reasoning. Because Mr. Musk was not a controlling stockholder, the stockholders' approval of the award in 2018 through a fully informed vote is sufficient to invoke business judgment review for the award. The proxy disclosed all of the economic substance of the award, and there's actually no dispute on that point. Under cases like Investors Bancorp and others involving fixed compensation awards, that is enough to justify the stockholders' approval. And so for those two reasons, we submit business judgment review should apply and the decision should be reversed. If the court were not to, if the court were to apply entire fairness, we submit the decision should be reversed on that basis as well. This court has made clear in recent decisions like Solar City and Maffei that the entire fairness standard is not impossible to satisfy. And if any transaction satisfies that standard, it's this one, as the stockholders indicated by approving it twice over. Mr. Musk would be paid nothing unless he doubled the value of Tesla. And the only way he would unlock the full set of options was if he grew Tesla 12-fold and also met challenging operational milestones and also complied with the stockholder protections in the award, including not selling his shares for 5 years and remaining at the company in a leadership position. Just to put that into perspective, a $10,000 investment by a stockholder in Tesla at the time of the award would be worth more than $100,000 at the time Mr. Musk satisfied the milestones and worth more than $200,000 today. That is, under any definition, we respectfully submit an entirely fair transaction to Tesla's stockholders.
Mr. Michel, you mentioned the Solar City case. Let me ask you about the independence of the directors. I think it's fair to read the chancellor's opinion as not making a finding because she said she wasn't making a finding. And what do we do with the dissonance between her statements in the opinion and the opinion in Solar City, where plaintiffs didn't even challenge the independence of certain directors, such as Ms. Denholm, and the court found after a full trial on the merits that the merger, Mr. Musk did not control the transaction at all. What do we do with that, given that they're not far in time and the board was nearly identical, but for two directors?
I think it's an important point, and I think it does cast real doubt on the board independence discussion that the Court of Chancery adopted. As you say, the court did not actually make a finding on that issue. I don't ultimately think this court needs to determine whether the board was independent. As I outlined earlier, I think there's a different path, which is to determine he was not a controlling stockholder and the stockholder vote was fully informed and business judgment applies for that standard. For that reason, I do think an important point is that much of the court's discussion in its controlling stockholder determination was based on the independence of the board, but that was misplaced in the controlling stockholder determination. That instead goes to the independence of the board, which is a separate question from whether there is a controlling stockholder. I think footnote 117 of the court's opinion in Solar City makes this point powerfully by saying that that would be extending Delaware law and explaining that there are much different consequences for the determination that there is a controlling stockholder from the determination that the board is not independent. So I do think that point is important to bear in mind when analyzing the controlling stockholder question. Even if the court were to conclude that there was a breach of duty here, of course, we submit there wasn't, the court should still reverse based on the remedy. It's black letter law that rescission is available only when it restores all parties to their positions before the transaction.
Your friends suggest that you waived that argument as well. I did take a peek at the pretrial stipulation where there was clearly put in play that rescission was being sought, and there was no pushback that I saw from the defendants. Would you mind addressing that?
Yeah, Justice Traynor, two responses to that. First, we cite in our reply brief that we did contest the rescission remedy. I think it was called a nullification remedy there. But in all events, the Court of Chancery clearly passed on that question, engaged in this reasoning, and I think this court can accordingly review that determination because it was passed upon below, in addition to being pressed below by us. On the merits of the rescission ruling itself, as I said, rescission is only legally available when it restores all parties to their positions before the transaction. And this remedy fails, I think, several times over because it doesn't restore any of the parties to their positions before the transaction. Mr. Musk, of course, cannot reclaim the years of work that he did, the nights that he slept on the factory floor, growing the company with the promise of unlocking the options that were available to him, nor can the company be restored to the position that it occupied in 2018 because compensating Mr. Musk now would be wildly more expensive given the much higher stock prices that are, of course, a direct result of his leadership of the company.
Mr. Michel, would you concede that there was a quantum merit claim available in order to compensate Mr. Musk?
I think the answer is no, at least not at this time. If the plan were ultimately fully rescinded, it's conceivable that he could bring a quantum merit claim against the company, but that wouldn't be available until after the adjudication of this case, in our view. And ultimately, I don't think the Court of Chancery actually, disputed too much the premise that the remedy was not actually restoring everyone to their position before the transaction. Instead, the court seemed to place the burden on the defendants to identify an alternative remedy, but we do respectfully submit that that conflicts with black letter law, that the plaintiff has the burden to show the remedy. And here, plaintiff, as the Court of Chancery noted, abandoned a request for any alternative remedy. It's not hard to understand why that would be. After all, the plaintiff and the company benefited dramatically from this transaction to the tune of 1,400% or greater returns for the plaintiff. So that, I think, if the court were to find a breach, leaves us squarely in the world of nominal damages.
Mr. Michel, on the point, before you get to your nominal damage point, there's no dispute in this record that Mr. Musk satisfied the market cap and operational milestones, as I understand the record. Is there a single case that you can identify where a court has equitably rescinded the compensation of an executive after successfully performing for years?
No, Justice Valahura, I can't, and I think it's notable the Court of Chancery invoked the Valiant decision, but Valiant, if you look at footnote 47, in which I believe my friend cites in his brief, that makes a point of saying that the compensation for services was not being rescinded. It was only the bonus on top of that. So that case does not support their position. I think this is a paradigm case for nominal damages if the court finds a breach, because nominal damages would recognize the breach. Plaintiff's attorneys could still seek an attorney's fee of a lesser amount, and that would bring an end to this litigation, which we submit as the right conclusion. Finally, if the court were not—
You're out of time.
Oh, I was going to just introduce Mr. Wall. Thank you.
Mr. Chief Justice, and may it please the court, Tesla's appeal involves a different question from what the court's been discussing for the last 10 minutes. Given that the Chancery Court found a breach and ordered rescission, what happens next? That's the question Tesla faced in 2024. An independent special committee put that question to our extremely active and well-informed stockholders, and an overwhelming majority voted to leave the plan in place, whatever its flaws, and move on. The court should give effect to that decision for three basic reasons. First, ratification rests on sound first principles. It has a long history in agency and trust law because it can be good for those, like stockholders, whom the law seeks to protect. Second, precedent. In Curbs, this court recognized the legitimacy of post-trial ratification and explained that it allows stockholders to leave in place voidable acts of directors. And third, policy. This was likely the most informed stockholder vote in Delaware history. Courts shouldn't override stockholders' informed decision-making about their own best interests. Reaffirming that fundamental principle would resolve this case. I also want to say a word up front about what we're not arguing. The Chancery Court seemed to view the ratification vote as an attack on or an attempt to flip the court's decision. It wasn't. Some stockholders may have believed the Chancery Court was wrong, some right, some may not have had a view. They were answering a different question. Given where we are now, what do we wish to do? Do we wish to keep this plan in place and avoid a massive accounting charge that could potentially wipe out the company's earnings for years? Or do we want to go back to the table and renegotiate with Mr. Musk? They made that decision with full information, including the benefit of the Chancery Court's 200-page decision. They had an extremely robust public debate, as everyone here knows, and 72% of them made a decision, a mature business decision informed by their own best interests. Ratification was an option. Stockholders, an overwhelming number, took it, and our basic submission is that courts should respect it. Once one
Let me
understands,
interrupt you. So in your view of the world, what happens to the Court of Chancery decision?
so I don't think anything happens to it in a sense, Mr. Chief Justice, which is to say, we're not here saying that the stockholders cleansed the breach. We're saying only that they accepted the results of the transaction. Now, that's sufficient to resolve this appeal because the only remedy that Mr. Tornetta sought was rescission. So once the need for that remedy is mooted, this appeal is done. In another case, they could have sought other forms of relief, like actual or nominal damages. They didn't seek actual damages here. What would they have said? This was the deal of a lifetime. In a case like that, there would still be things for this court or the Chancery Court to do. But here they sought one equitable remedy. The stockholders voted to moot that remedy by ratifying the transaction as incurred, and that's sufficient unto the day. So I don't think it wiped out the Chancery Court's decision, but for purposes of this appeal, it ends the only issue before this court. I do think that's really important, Mr. Chief Justice, because I think the Chancery Court's view that ratification was an attempt to flip the court's decision colored both procedure and substance. And once you take that away, I think you look at the text of 54B, it says at any time before judgment, litigants all the time walk in and raise intervening circumstances. And you have curbs saying, as a matter of substance, as long as you have a non-coerced and fully informed vote, you can ratify. Now, to be sure, curbs is 73 years old, but I think that's a good thing, which is to say this is a safety valve, not a floodgate. It will be a very rare case in which a derivative plaintiff successfully seeks relief that a majority of disinterested stockholders in a fully informed vote reject. But in the rare circumstance where that happens, it seems to me very important that stockholders be able to say, this idiosyncratic derivative plaintiff has managed to achieve relief that we do not believe is in the best interests of the company or of us as stockholders. And it seems to me preserving that safety valve under Delaware law is critically important so that stockholders have the ability to say what they want to happen for their company and for their own interests in the company. And so from our standpoint, it's really important that the court preserve the ability of the stockholders to say that. We think this is the system working. Stockholders had a fully informed vote, non-coerced. Some changed their mind. Some institutional investors like Vanguard that had opposed the 2018 plan then supported it in 2024. Others who had supported the 2018 plan changed their mind and they didn't support ratification in 2024. But overall, after that robust debate, you had almost exactly the same percentage, 72 as opposed to 73%, saying, we want to ratify and keep the 2018 plan in place. We want to move on. We do not want to take this massive accounting charge. And that's exactly what we should want stockholders to be doing as a matter of corporate democracy. We want them to engage in debates like that with full information to make a decision about their best interests. And we respectfully submit that Delaware courts ought to respect the result of that vote. Keep in mind, this is originally what Mr. Tornetta asked for. When he came to court, he said, you ought to put this up for another stockholder vote. And we ultimately pivoted away from that and went for the moonshot of rescission. But originally, even Mr. Tornetta said, look, put it to the stockholders with better information than what they had in the 2018 plan. Again, it's hard to imagine what would be a better informed vote than this one. They had the decision, they had a summary of the decision, they had the benefit of perfect hindsight about how Mr. Musk and the company had performed, what they would be paying him, and how their own stock had performed. It's impossible to imagine what else they could have known. And in the face of that full information, they took a free and fair vote about what they believed their own interests to be. I do want to say just a word about fees. If we're right about ratification, then of course, Mr. Tornetta's counsel doesn't collect $345 million for the therapeutic benefit of achieving a ratification vote. But even if we're wrong about ratification, it was still a legal error for the Chancery Court not to net out the benefits and the costs. No one's here arguing that Mr. Musk has had to work the last 7 years for free, meaning everyone knew and agreed that he was going to have to be paid something. Mr. Tornetta agrees with that on page 88 of their brief. At that point, the Chancery Court needed to net out the cost of that replacement plan. Otherwise, it's a windfall to the plaintiffs. And that's what happened here. That's a legal error. It's not a factual error. And so no matter what, this court should take the fees down. We've suggested a no more than 4x of the lodestar or a maximum of 54 million. I welcome any of the court's questions.
Thank you
That's
very
my
much.
time. Thank you.
Mr. Varela.
May it please the court. Greg Varela for Richard Tornetta. As the court's well aware, this is defendant's appeal from a trial judgment for plaintiff and subsequent decisions denying defendant's attempt to overturn the verdict using a post-trial ratification vote and awarding plaintiff's counsel a fee. I submit to the court that there's nothing extraordinary about this trial opinion. It's based on careful fact-finding and application of settled law to those facts. What makes the case truly extraordinary is that it addresses the largest pay package in human history. It's not an overstatement. It's the largest package in history, awarded to the richest man on earth and someone who is also one of the most powerful men on our planet. The trial court did its job without regard to the personalities involved. The chancellor found facts, applied the law, and did equity. This is the case into which this court steps. The court should affirm because, first, the trial court properly applied the entire fairness standard. Second, the remedy granted was appropriate. Third, ratification has no place as a post-trial defense. And third, finally, the lower court properly exercised its discretion to award a fee of 0.6% of the benefit it found the litigation to have created. Entire fairness was the appropriate standard of review for three independent reasons. First, Musk exercised transaction-specific control over the process by which his compensation was set. That is a finding of the lower court. It's based on extensive evidence. It's entitled to deference, and it triggers entire fairness review. Second, the lower court—
So let me just stop you on the first one.
Yeah.
How much of that depended upon his status as a superstar CEO?
None, Your Honor. The superstar CEO discussion in the lower court's decision is a discussion of a recent academic article. The court did not base its findings on that. She used it as descriptive of the governance dynamics she was examining, but no finding is based on that article. And with respect to the press and the Fourth Estate, I think it was badly reported with respect to the discussion of the so-called superstar CEO. That wasn't a ratio decidendi for the decision at all, I would submit to Your Honor.
Mr. Varela, while we're still on the point of Mr. Musk's control, part of the appellant's argument is that some of the court's findings depended on his actions after 2018 and after the pay package was adopted. Do you concede that our focus for purposes of actual control is at the time of the transaction?
Your Honor, it is certainly part of what we need to show that there was actual control in connection with this transaction. So if that's a concession, yes, I make it. But I also think it's relevant for the court to examine, among other things, matters that happened afterwards to elucidate the nature of the control. Let me give you a simple example. There was an SEC settlement entered into by Tesla with Tesla and with Mr. Musk. That SEC settlement called for active oversight by, among others, the chairman of the board of the company. The court looking at that concluded that during a whole period of time, both soon after this transaction was negotiated and leading on for years, the company did a terrible job. It didn't do its job of monitoring Mr. Musk, monitoring his statements, and exercising control that a board was required to under an SEC consent decree. And in that context, the court said, well, look, this is more of the same. But the direct answer to Your Honor's question is we were able to demonstrate control in connection with this very transaction. And that control rests I think is most clearly demonstrated by the court's findings with respect to timing in connection with this transaction. Now, with respect to timing, the court made a number of findings, but the court found that Mr. Musk repeatedly and unilaterally manipulated the timeline of the process, and that exercise of control, and I'm quoting here, negatively affected the process. You can find that at pages 162 and 163 of the opinion. So there was actual exercise and it had an effect, said the court. I would also say, Your Honor, that there is another reason why entire fairness was the appropriate standard of review here. And the test applies because the vote of stockholders in this particular case was a condition precedent to the effectiveness of the grant. This was not a precatory vote. The vote of stockholders in 2018 was necessary to give life to the grant, and without it, there was no grant. Now, the defendants conceded in post-trial briefing that any material disclosure failure should trigger the entire fairness standard. You can find that in the appendix at A1678 and A1737.
But they argue that you missed the caveat to that, which is assuming he was a controlling stockholder, right?
Yes, Your Honor, they do in one of their descriptions drop a footnote and they say, but we still argue he's not a controlling stockholder. But this was in response to the lower court's direct question. She said, you have a vote. If I find material non-disclosures, what happens? We had argued to the court that any material non-disclosure automatically voided the plan because of the fact that the plan hinged upon and was conditioned upon the stockholder vote. The other side argued, no, you don't go automatically to rescission, you go to entire fairness instead. And the court based its thinking, at least in part, on that independent ground. So, Your Honors, if I may turn to transaction-specific control, as obviously it's a form of control that this court has recognized in Oracle. And the defendants themselves, as Your Honor pointed out, in their briefs below, recognized it as a path to entire fairness as well. The lower court found transactional control because Musk had significant ownership in the company and, according to the court, wielded the maximum influence that a manager can wield over a company. Musk exercised control over the timing of the grant and process, which I've addressed just a moment ago. A majority of the directors voting for the grant were beholden to Musk or beholden with respect to the grant process itself. The director's actions evidenced a controlled mindset, held the court, and there was also proof of general control, which can be used to also augment proof of transactional control. The court's conclusion wasn't tentative. It found that this unique suite of facts made it, quote, undeniable, close quote, that Musk exercised control with respect to the grant, and that's page 112 of the opinion. I've addressed timing a moment ago. Let me turn to independence and try to respond to the question Your Honor had for my colleague. The court found 3 directors, Kimball Musk, Antonio Gracias, and James Murdoch, generally beholden to Musk, and 3 others, Ira Ehrenpreis, Robin Denholm, and Brad Buss, beholden in connection with the grant. Now, I heard Your Honor's question about what I would characterize as cognitive dissonance with the Solar City opinion. And the simplest answer is, Your Honor, we had a different record here. We had a well-developed record here, and we challenged independence from the outset of this particular case. Her Honor dealt with the very question Your Honor asked in a footnote. I don't have the footnote memorized, but there is a footnote in the opinion where Robin Denholm's independence is addressed. And Your Honor may remember that in Solar City, then Vice Chancellor Slights made a comment to the effect in a footnote in the trial court opinion that he had great regard for Robin Denholm, that she had acted independently with respect to the so-called special committee there, even though it wasn't actually a special committee. And I think the Vice Chancellor said about Ms. Denholm in that case that if she said it, he's relying on it. Well, as the Chancellor held in this case on this record, That finding with respect to what Ms. Denholm may or may not have done in the Solar City transaction is perfectly good, but it doesn't make her independent for all purposes for all time. This was a different record, and Ms. Denholm did not shine on this record. There are extensive findings about her lack of independence and her beholdenness to Mr.
What
Musk.
about the court's statement that it wasn't making independence findings at all?
So-
What weight do we give all of these statements?
So, Your Honor, first of all, the court did make that statement, but what she also said was that if she was required to make a finding, she would likely find a lack of independence. And I think what you have here is an extraordinarily crafted trial opinion and a judge who is carefully trying not to make decisions she is not required to make. To the extent she's able to come to a conclusion without reaching a subject matter that she's not required to make, I think she's exercising admirable judicial restraint by not making that finding. She found beholdenness, and as a matter of fact, not only did she find beholdenness, she found that the actions of this board in connection with this very matter were probably as close to an admission, her words, of beholdenness or controlled mindset as a plaintiff's lawyer is ever going to make in Delaware courts. That's a remarkable thing for the court to say. In light of the record and that finding, the court concluded she didn't need to go further and make independent judgments about independence, but she left you a footnote saying that if she was required to do so, she would probably find a lack of independence. Remember, Your Honor, beholdenness and independence have been dealt with independently in our court's jurisprudence. And having found the beholdenness to the controller for purposes of this analysis, the court simply exercised judicial restraint and didn't make a finding she wasn't required to make under the law. So, Your Honor, let me turn, if I can, to just briefly to the disclosures here, because I think they're very important. And it's very clear, based upon what the other side has conceded, that you don't need to deal with transactional control if you find that the court should be affirmed in connection with its holding with respect to misleading disclosures, materially misleading disclosures. The proxy paints a picture of a committee of independent directors acting at arm's length and first discussing Musk's compensation among themselves. The record, however, shows that the compensation chair, who the court concluded was beholden to Musk in connection with the grant, approached Musk, and that it was Musk who set several of the key terms of this grant before the compensation committee was even briefed. The lower court found that the proxy's disclosures regarding the committee members' independence and the grant's development were material and false. The court described these as, quote, two clear winners, close quote, at page 148 of the opinion. With respect to the proxy's description of all compensation committee members as, quote, independent, close quote, the lower court concluded that both actual and potential conflicts of interest had to be disclosed. The court concluded that the claim that Mr. Gracias was independent was simply false, and that Gracias and Ehrenpreis's investment relationships with Musk and his private companies gave rise to conflicts that needed but were not disclosed. The lower court also found that the proxy omitted the fact that Mr. Musk set the structure of the grant in the initial phone call on April 9th, 2017 with Mr. Ehrenpreis. The court addressed two additional disclosures, and in the exercise of a conservative approach to not making findings she didn't need to make, she found these two additional disclosure failures likely material. That's page 156 at footnote 775, but she didn't reach them because she didn't need to reach them. Those disclosures related to the achievability of the grant's milestones and Musk's status as a part-time employee. Based on defendant's own admission, the entire fairness test was properly applied, regardless of how and whether you reach the question of control. Applying entire fairness review, this court took a page from the court's direction, the Court of Chancery took a page from the court's direction in Solar City and analyzed the Weinberger factors, laying them out in order. As for timing, as I noted earlier, the court found Musk unilaterally manipulated the timeline of the process and that his exercise of control negatively affected the process. As for negotiations, the court found a stunning lack of arm's length negotiations, which it characterizes the most dramatic failure of the process. Specifically, Musk found, and I quote, Musk dictated the grant's terms and the committee affected those wishes, close quote. That's page 169. As for approval, 5 of 6 directors were beholden to Musk or had compromising conflicts, said the court at page 170, and approval was secured through a materially deficient proxy. In short, the other side failed in its burden of demonstrating the fairness of the process. Turning to price, the trial court held where, and I'm quoting now, where the pricing terms of a transaction that is the product of an unfair process cannot be justified by reference to reliable markets or by comparison to substantial and dependable precedent transactions, the burden of proving to the court the fairness of the terms will be difficult, close quote. That's pages 171 and 72 of the opinion. Concluding the defendants failed to carry their burden, the court found a lack of negotiation over the grant size, a conscious decision to avoid even considering available benchmarking data. And I pause here for a second to say, Professor Murphy from UCLA was put on by my friends, the defendants, at trial. Murphy had testified earlier in the Court of Chancery in the Disney compensation case that benchmarking was not only available but required, and that a board who didn't consider benchmarking data in considering compensation was breaching its fiduciary duties. That is one of the experts that my friends on the other side put on, and the evidence here is that this benchmarking data was available and simply ignored by both the compensation committee and the board. In addition, there was a failure to explore whether the goal of keeping Musk might be achieved with less. There were no guardrails put on the time Musk actually spent. And importantly, defendants failed to show that Musk's efforts were the causative factor in the positive results Tesla achieved over time. Turning briefly to remedy, the trial court found that rescission was reasonable, appropriate, practicable, and uniquely available. Those are all direct quotes from page 198 of the opinion. There were no third-party interests involved here, and the court found as well that this court has held that rescission is the preferred remedy when a breach of the duty of loyalty is found, citing this court's venerable decision in Lynch against Vickers.
Mr. Varallo, number one, how is Mr. Musk put back to the status quo ante after 6 years of achieving what he was asked to achieve? And number two, do you have a case where a court has equitably rescinded an executive's compensation after years of work?
So, Your Honor, to answer your second question first, yes, the case is Valiant versus Journey. It's the closest that our law comes.
That was not rescission, that was disgorgement.
Well, Your Honor, what the court said, and I will quote the court directly, and I'm quoting now from page 752 of Valiant versus Journey, found at 921A second, because Journey, who is the defendant, has failed to show that this transaction was entirely fair, it is clear he has no right to retain any of the $3 million bonus he received. As between Journey and the company, that payment must be rescinded, period, close quote.
That was a case where a restructuring was aborted and bonuses were awarded to parent company management who would have no involvement in the company going forward. And the court said it was disgorgement. This is rescission, and the court found you didn't seek any other remedies. You abandoned your other remedies. And if we were to determine that rescission isn't appropriate here, aren't you left with nominal damages?
Your Honor, there are two answers to that question. First of all, I have to say that disgorgement and rescission are flip sides of the coin. In a circumstance where a defendant actually received money, which was the case of Mr. Journey, he is disgorging it when the court says give it back. That is disgorgement from his perspective. But as I just read to you from the company's perspective, it is rescission. They are flip sides of the same coin, and it matters whether or not the individual has actually received something they have to give back. In this case, there wasn't something in Mr. Musk's hands he had to give back, so disgorgement wasn't in play. It was rescission because it was simply sitting there. In terms of our remedy, Your Honor, we were the only ones who put forth an alternative remedy in this case. And that alternative remedy was partial rescission. Should the court conclude that partial rescission wasn't appropriate and that full rescission wasn't appropriate, nominal damages would be one rational way to approach the matter. We don't believe that would be appropriate in this particular case. However, there was a clear breach of fiduciary duty of loyalty proven below, and the court's extensive work lays that out in great detail in 201 pages of the liability trial
But
opinion.
the Court of Chancery said it had no record before it to do anything else. And as the Court of Chancery said in Ravenswood, equity isn't a license to make stuff up. So if there is no record and there's no other remedy, are you asking us to come up with one?
No, Your Honor. First of all, that misplaces the burden. The burden of demonstrating an alternative to this particular package was not ours. It was held correctly below to be the other side's, and the other side went all in this particular case. They decided to gamble 100% on the simple question of whether this grant was fair or not. That's how they tried the case, and there is a consequence to trying the case that way. And if they lose, they lose. They get nothing. Now, what we learned again in Valiant versus Journey, a case that Vice Chancellor Lamb tried, he was asked the same question that my friends are asking you to think about today. He was asked by the defendant, look, I got a $3 million bonus that you're ordering me to disgorge. But you know what? I added value. And what you ought to do is require me to disgorge something less than $3 million, because you, the court, ought to find some number that was fair for my bonus. So if $1 million was fair, I should only have to give $2 million back. And Vice Chancellor Lamb flatly rejected that. And he rejected it because he said, Mr. Journey, the defendant, didn't carry any burden to demonstrate what a fair bonus would have been. He went all in on the $3 million. Exactly the same case here. My friends had the opportunity to put in alternative evidence. Gosh knows they put on 2 different compensation experts. Neither of them addressed at all what a fair compensation for Mr. Musk would have been if the case was rescinded. Having failed that burden and made a conscious decision not even to try to carry it, it's not a matter of us making stuff up in the words of the case Your Honor cites. It's a matter of my friends having failed in their burden, and there's a consequence to that failure.
Could you get to ratification? I don't
Sure.
want you to run out of time.
Yes, Your Honor. Ratification doesn't work here for several reasons. First, it's an affirmative defense available before trial. Second, there's no clear procedural mechanism for admitting new or newly created evidence to flip a trial record. And third, and perhaps most importantly, stockholders simply don't get to reverse this court's holdings or remedies or those of the Court of Chancery. First, we've got cases like Investors Bancorp and Michelson versus Duncan, which make clear in our law that ratification is an affirmative defense. It was raised in Investors Bancorp at the motion to dismiss stage. It was raised at Michelson at the summary judgment stage. And in this case, had it been raised pre-trial, it might have shifted the burden of proof, but it would have not changed. You can't change the court's outcome now by raising it after the fact. Holding otherwise would make lawsuits interminable and run directly into Lord Coke's admonition more than 400 years ago that should there be no end of suits, then a rich and malicious man would infinitely vex him who hath right by suits and actions. That's from Ferrer versus Arden, cited in our
Could you
briefs.
address curbs? That's the main case. you're
Certainly, Your
relying
Honor.
on.
Curbs is an interesting case, and I think it's been poorly addressed here. There is nothing in Curbs, and I repeat, there is nothing in Curbs that reaches as far as this case. Curbs dealt with 2 plans, a stock option plan and a profit sharing plan. So there was a motion for injunction, and the court denied the injunction in the trial court. When the injunction rulings came up to this court, there had been earlier, prior to the hearing in Chancery, a ratification vote on one of the 2 plans, the stock option plan. When the court got that, it said, well, that pre-hearing early ratification vote was sufficient to ratify and cure the fact that a majority of directors were interested. But this court held, notwithstanding that ratification vote, that it did not cure, that vote did not cure defective design of the plan. And this court ordered an injunction notwithstanding the ratification. Meanwhile, the profit sharing plan also had not been enjoined. And when the profit sharing plan comes up together with the stock option plan, after the hearing in Chancery, there had been a separate ratification vote on the profit sharing plan. This court didn't make rulings other than to say, send that back to Chancery to determine what effect, if any, the ratification vote had on the profit sharing plan. Now, on remand, the Court of Chancery concluded, as this court had hinted on the stock option plan, had ruled on the stock option plan, that the ratification had the effect of curing the interested director vote. However, the court simply repeated its earlier holding, not enjoining the profit sharing plan. It was consistent with the earlier ruling, and that never came back up to this court. So what I'm telling you, ladies and gentlemen of the court, is this court has never made a ruling on the effect, if any, of a post-trial ratification vote. And let me tell you why.
Thank you very much.
Thank
Mr.
you, Your
Varela.
Honor. I appreciate it.
Your Honors, this is an exceptionally odd case. I've never seen anything like it. A CEO said, don't pay me unless I double the company. And from there on out, don't pay me unless I create the equivalent of a Ford or a General Motors or a Federal Express every 10 months. It'd be laughable if we didn't know with the benefit of hindsight that he'd done it. And 73% of stockholders said, I'll take that deal. A derivative plaintiff who holds 9 shares managed to get that executive compensation award set aside and to achieve the largest fee award in Delaware history of $345 million for his counsel. 72% of stockholders in a fully informed vote said, we don't want that again. Whatever the court's path, that result shouldn't stand. And as the court's questions have laid out, I think there are 3 paths to get there. The first is on control. Mr. Varallo and I think read the Chancery Court's decision differently. The Chancery Court cited the superstar CEO theory a dozen times. It was central to the Chancery Court's determination of control. But what the Chancery Court was talking about wasn't control in terms of stock ownership, but influence or leverage. The Chancery Court was conflating the question of control with the question of board independence. As you pointed out, Justice Valera, yes, the Chancery Court didn't reach a finding on that, but this court easily could, because between the record here and Solar City, there is plenty before the court to show that the directors were independent. At a minimum, though, the court would have to remand on that because the Chancery Court did not reach a finding on independence. The vote was also fully informed, so that also would be enough. There's no question that the proxy disclosed all the material terms of the award to Mr. Musk, which is what Investor Bancorp requires. Justice LeGros, you're also right. The Chancery Court's control determination was sort of wrong for another reason, which was it relied on facts after the transaction. The director's brief does a nice job of pointing that out at page 20, and then in the reply at page 10, footnote 2. Both of those are reasons why the control determination was error, and the path's route to entire fairness strayed from the law. Justice Valera, on rescission, that's the second path. So you could go control and independence or an informed vote of the stockholders. That would be the first path. The second path would be rescission. And the answer to your question is yes. The parties here could not be returned to their original positions. Tesla and the stockholders can't give up the benefits of Mr. Musk's incredible labors for the last 7 years, nor can Mr. Musk give back all of the work that he put into the company over those years to achieve that extraordinary success.
So whose burden was it to put in that mitigating evidence?
It was the plaintiff's burden, Mr. Chief Justice. The plaintiffs came in seeking rescission, so it was their burden, as with any other remedy, to show that that remedy was warranted. So it's a case not different from Ravenswood, where the plaintiff comes in a derivative case, shows a breach under entire fairness, but the court says, you haven't shown that you're entitled to rescission because the parties can't be restored to their original positions. So you're left with nominal damages. Obviously, there's no actual damages claim here, nor could there be. So it's really no different from Ravenswood. They shot the moon on one remedy, rescission, and black letter law says they're not entitled to it. And it's their burden to show that they get that remedy, as with any other plaintiff and any other remedy. That's the second path. The third path would be ratification. Mr. Varello makes a lot of the fact that this was post-trial, and he says it's an affirmative defense. That's wrong. It's an affirmative defense as to the directors if this had happened before trial. The directors would have to come in and plead it as an affirmative defense that would get them out from under the breach. It's not an affirmative defense as to the company when it happens in the middle of litigation. Then it is simply the company and the stockholders coming in and saying, we want to accept the results of the transaction. We're not cleansing the breach, no more than when a principal says that he wants to ratify a Wayward Agents Act or a beneficiary wants to ratify a Wayward Trustees Act. Neither the principal nor the beneficiary is necessarily saying that the agent or trustee did nothing wrong. They're simply saying that even if you breached your duty to me, you achieved a result that I like, and I shouldn't be left worse off by the law because you achieved a result that I like. And that's what ratification is. As long as you're fully informed, you can take it. And CURB says you can take it even post-trial as long as the vote is fully informed. Here, they had the best possible information. What would they have voted on before trial? They had already voted for the 2018 plan. Only once the Chancery Court adjudicates the breach is there new information to put in front of the stockholders. There's no argument that information wasn't put in front of them. They knew everything they needed to know about this pay package, how the company had performed in hindsight, what the massive accounting charge would be going forward, and whether they wanted to take the results of that deal. Mr. Varello talked a lot about the disclosures for the original plan. He didn't say a word about the disclosures on ratification because everything relevant was disclosed to the stockholders. This is like Investors Bancorp. Do they know what they're voting for? That's the key. And stockholders in 2024 knew exactly what they were voting for. They were voting for a specific plan, the terms of which had been clear for the last 6 years. So that's the third path. Whether the court, like which of those three paths it takes, obviously up to the court. If it's either rescission or ratification, either of those is a very straightforward way to resolve the case. The appeal is over, the plaintiff's lawyers get a quantum merit fee, and we're done. I think that all three of those are independent paths to reaching the right result, which is that whatever the court says, the result below can't stand. The stockholders of this company voted twice to reject the relief that this derivative plaintiff is seeking, a relief that leaves them and the company worse off because to negotiate any new compensation package for Mr. Musk would cost the company literally dozens of billions of dollars that would skew its balance sheet for years to come. The stockholders were entitled to say they did not want that relief as long as they were not coerced and fully informed, and that's what they did. So whether as a matter of control and independence, rescission, or ratification, the court should set aside the result below, enter judgment for the directors of the company, allow the plaintiff's counsel to collect a quantum merit fee, and this case should be over.
Thank you very much, counsel. We appreciate the arguments. We'll take the matter under advisement.